All right. Well, welcome everyone. Nice to see everybody here today. My name is Matt Killian. I'm the president of the Brainerd Lakes Chamber. I want to thank you on behalf of all of our chamber partners, including, of course, the Brainerd Lakes Chamber, but also Cindy at the Cross Lake Chamber, Aubrey at the Cuyuna Lakes Chamber, Pam at Nisswa, and Nicole at Pequot Lake. So this is a true chamber collaboration to bring you the webinar today. We are all shameless advocates of pro-business policy, and we work in government affairs at all levels. When there's a law that affects businesses like yours, we like to bring you up-to-date, very reliable information so you can confidently run your businesses. So that's what we're doing here today. I'll give you a little bit of the basics. I'll introduce our presenters and then we'll get going. A lot of this you already know. In the 2023 legislative session, there was a new law after many years of debate. And on August 1st, Minnesota actually became the 23rd state in the United States to legalize recreational marijuana. And now adults ages 21 and older may now legally possess and grow cannabis for recreational purposes. So since that happened and we saw all the media coverage, we started getting lots of questions from our members on both customer issues and employee issues. And that's why we gave a call to Winthrop and Weinstein and thank them for taking time to present to you today. Winthrop and Weinstein is a Minneapolis-based law firm, and there are three numbers I'll throw out there. 160, there's 160 plus attorneys representing businesses in 14 different industries and 65 different practice areas. We're happy to welcome two of their attorney shareholders back to the Brainerd Lakes area. They've been here before. Laura Pfeiffer and Mark Pyhart will provide an overview of the new law and what it means for you as small businesses and organizations. Throughout the webinar, we will ask you to put your questions in the chat, and Mark and Laura will monitor that and get to those questions along the way. We'll also take questions at the end. We think the webinar will probably go, the presentation anyway, will probably go 45 minutes, and then we'll make sure to leave that last 15 minutes for questions as well. Later this week, you can check the chamber websites for a webinar recording and a blog recap. And then I believe it will also be covered in the Brainerd Dispatch. So I believe we have the Brainerd Dispatch, one of their reporters here as well. So thanks for being here. And with that, Laura and Mark, I'll turn it over to you. Thanks again for your time.
Great, thank you. So we'll switch it over to our slides and get started. So first of all, thank you so much for the nice introduction, Matt. Mark and I are pleased to present on this topic today. We've presented on it before, and one of the things I was just, our information is on this first slide, and we're happy to answer follow-up questions. But Matt had let us know that he found us initially because one of our publications on our website, which is winthrop.com, but we have an article on frequently asked questions on this topic that I encourage people to look at as well, and then I know that you have access to our slides too. But again, thank you so much for having us. We're happy to talk through these issues with you. And as Matt mentioned, our firm is headed up to the Brainerd area for our firm retreat early next week. So we're going to be up there very soon. All right, so our agenda for today. We've broken up the presentation into 4 areas, and as Matt had mentioned, if there are questions and you put them in the chat, we'll see if we have an ability to address them as we go, and we're reserving time at the end to also address those. But if you type something in, we'll attempt to see if we can answer it as we go, if it fits into the topic we're talking about right then. So the 4 areas that we're going to break out the presentation in today are as follows. So First, the new cannabis law, just to give a high-level overview about what the changes are. Matt mentioned some of them, but get into that in a little more detail. Second, employees and cannabis use. What are some of the different considerations in hiring, testing, and responding to cannabis use in the workplace as it relates to your employees? Third, updating policies and procedures. What do you really need to know as it relates to the new law and making updates so that you can best protect your business? We'll provide you with some tangible takeaways as to things that you should adjust or that we recommend that you do after seeing the webinar. Fourth, restricting customer use of cannabis on your business premises. What are the rules related to that and what do you need to know? And then finally, questions and answers. Go over questions that you guys address.
Hopefully we'll have the answers.
Yeah, right, so best laid plans so we will know the answer and be able to answer those for you. All right, so we like to start this presentation with a bit of a spoiler. And so when I'm listening to webinars, sometimes I am admittedly doing two things at once, maybe doing some work and listening to, and so when the presenter says, okay, here's something you really need to remember or a takeaway. So this would be in that category. First spoiler is nothing we're going to tell you today suggests that employers need to allow employees to use, possess, or distribute cannabis at work. These are things that you are able to regulate and you do not need to tolerate in your workplace. Second, nothing we're going to tell you suggests that your employees are allowed to be impaired at work. So even with this new legislation and the fact that there are some challenges that Mark will talk about more in the impairment test for cannabis and how do you interpret that, nonetheless, that does not mean that your employees are allowed to be impaired at work and you are able to take action with that. You'll just want to make sure that you're doing so in a way that's consistent with the law, and if you need to shore up any policies that you are doing that to give yourself as a business the greatest latitude to make those changes. All right, so starting with a general overview of HF 100. Matt had mentioned that this was signed into law by Governor Walz May 30 of 2023, went into effect August 1 of 2023, and did make Minnesota the 23rd state to legalize cannabis use for adults. Some of the things that the law outlines is that if you are 21 or older, you may now use, possess, or transport cannabis paraphernalia. You can possess, transport up to 2 ounces of cannabis flower in a public place, and possess up to 2 pounds of cannabis flower in a person's private residence. So there's some other provisions as well, but those are some of the main ones as it relates to the adult use of cannabis. The law also establishes the Office of Cannabis Management. It establishes and provides an initial framework for the cannabis industry. As you might expect, there's going to be a lot of infrastructure and rulemaking, especially as it relates to dispensaries, and all of that is going to take some time. It provides for taxation and appropriate spending, including the Center for Cannabis Research at the University of Minnesota, which is studying some of the effects of substance abuse and the effect on health in the public. It reworks the criminal code to account for legal cannabis. So cannabis now, because it is legal for those that are 21 and older, is going to be treated more like how alcohol is treated as it relates to the criminal code. It makes changes in Minnesota laws regarding drug testing. That's a big focus that we'll be talking about today. We are both employment lawyers, and so drug testing is a question that we have been fielding for the last 28 years or so, and especially in Minnesota, that is it's a very specific statute. It's very unique in Minnesota, And if you do drug test, and some of you that do already, I'm sure are familiar with it, there are specific things you need to follow, and also with this new change that you need to adjust in your policies. And finally, HF 100 provides certain parameters regarding employer responses to cannabis in the workplace. All right, so again, starting with a high-level summary, and we'll get into some of these things in more detail. First, cannabis is now a lawful consumable product under Minnesota Statute 181.938. And in a couple of slides, I'll talk more about that statute. It is something that has been around for some time, and it is a statute that we regularly get questions about. Previously, we got questions more about alcohol use as it relates to the lawful consumable product statute. But we'll talk a little bit more about the intersection of that statute with cannabis. But cannabis now is officially a lawful consumable product under that statute. It's important to keep in mind that cannabis is still unlawful under federal law. So that is a change, or it still is the case. And so most of this presentation relates to employers that do not have those federal requirements, but we don't want to lose sight of the fact that if you do have federal contracts that require different requirements or DOT requirements, that all of those still apply and are different than some of the things we'll be talking about today. Lastly, on this slide, cannabis is no longer a drug under the definition of drug and alcohol testing under the Minnesota Drug and Alcohol Testing in the Workplace Act, which is the acronym for that is DATWA. And so we'll talk about DATWA. Like I had mentioned, it is a very specific statute in Minnesota that if you are testing, you need to do so in accordance with that statute and also have a written policy that makes that clear and have your employees or applicants acknowledge that policy. So if testing is something that you are interested in doing or that you are currently doing and already have a policy related to that, you'll want to make sure that that is updated so that you can test consistent with that, and also that you're not testing for things that you're no longer permitted to under that statute, but we'll talk about that in a second. All right, so continuing with the high-level summary, legalization of cannabis in Minnesota affects all stages of the employment relationship. So pre-employment, generally speaking, the new law prohibits lawful cannabis use from adversely affecting employment candidates. And there's changes as it relates to what you can test for pre-employment that we'll talk about. And also that you're not, because of this lawful consumable product statute that we'll talk about, that you're not taking that out on employees for lawfully using outside of working hours. It can't adversely affect candidates. During employment, the biggest changes are on the policies and how you interpret those policies and whether you need to adjust those. And then terminating employment, Mark's going to talk about that in more detail. Or what should you be looking at to lawfully terminate somebody as it relates to cannabis use? All right, so the lawful consumable product statute. I feel like it's always kind of a mouthful, right? Like that statute, right? So, and when we did this presentation before, it was like, well, what does this even mean? And like, how do you interpret that? So an example that I think is useful to go over here is that we would often get questions from employers, and a hypothetical would be, so you have an employee that is out at a local bar. They are drinking and are very intoxicated at that bar. And that business wants to take action about that because they feel like that person's behavior in being very intoxicated at that bar is a poor reflection on the business. So they'll call us and ask, can you terminate, this person, or can we at least discipline them for acting in this way at a local bar? And This is not, in my hypothetical, it's not a company-sponsored event. It has nothing to do with the workplace. So it's someone that is of age, they are legally drinking, and they are at a local establishment, and the company feels that it's poor reflection. Well, the short answer is that it is not permissible to take action because that person was engaging in legal behavior, in this instance, alcohol, outside of work premises. It has nothing to do with work and in non-working hours. So if we take this hypothetical to extend now to cannabis, this statute was revised to specifically include cannabis as a lawful consumable product. And so accordingly, the employer cannot take action if the person is using cannabis. Again, it's not related to work, it's non-working hours, it's off the employer's premises. And so this folds in cannabis to this lawful consumable product statute, and the same answer would apply. You can't take action against an employee for lawfully using cannabis outside of work in non-work hours.
Simply for that reason. I mean, there could be other circumstances related to their behavior outside of work that might reflect poorly on the company that you want to take action against them for, but just because you as an employer don't like the use or abuse of alcohol, or in this case, the use or even the abuse of cannabis, that can't be the sole reason for taking action.
All right, and so cannabis is included in this lawful consumable product statute, irrespective of the fact that federal law treats it differently. But then in the second bullet point, this is hearkening back to my spoiler at the beginning, is that the statute made clear that nothing in these revisions to the statute or the statute itself shall be construed to limit an employer's ability to discipline or discharge an employee for this use if it is during working hours, on work premises, or while operating an employer's vehicle, machinery, or equipment, or if failure to do so would violate federal or state law or cause an employer to lose a monetary or licensing related benefit under federal law or regulations. So the legislature did try to make that part clear, that if it does intersect with working hours, work premises, or operating machinery, that you still may take action. But again, if it is outside of those things, that's where this lawful consumable statute comes into play, and that you want to just be aware of that. All right, so the next thing we're going to talk about is testing in the workplace. And just to level set at the beginning, one question we have been talking about more is, do employers need to test at all? Right, so, and I think the short answer to that is that unless it is required by federal law, that the answer to that is no. And many of our clients are carefully looking at and reevaluating testing, period. There have been severe labor shortages, such a tight labor market. Some of our employers think it's in the category of be careful what you wish for, like do you want this information? And then as Mark will go into more detail, there really isn't a good impairment test for cannabis right now. And so even if you are permitted to test, do you want to test? Does that add value? What does that look like? So assuming that you are interested in testing in some capacity, as I mentioned, Minnesota has DATWA, that drug testing statute, and it's important to make sure that you're following that and testing consistent with that. So some of the changes is that the statute redefined drug and alcohol testing to no longer include cannabis or cannabis testing. It creates a new term for cannabis testing, and pre-employment testing is limited to drugs. So no pre-employment testing may be done for cannabis unless an exception applies, which we'll talk about in more detail. So if you have an existing drug testing policy, it will need to be revised, and very likely so, because of the fact that a lot of our old policies would talk about illegal drugs. And so since this drug has a different definition, Again, it's not a very complicated revision, but you do want to make sure that you're taking a look at that to make sure that you're not still just having, even whether it's your testing policy or your policy as it relates to no impairment in the workplace, a drug-free workplace, that you are specifically revising those policies to ensure that you're not just using the word drug. You want to actually take the time to revise them to also prohibit cannabis. Other than that, other drug and alcohol and cannabis testing rules remain largely unchanged. All right, so again, for the in the category of things to take note of is that there are these clear restrictions that you cannot pre-employment test for cannabis unless there is a federal requirement or an exception is made or an exception is met. And so here's the exceptions, and this is the part that I want you to take note of, is that you cannot test for pre-employment for cannabis unless one of these exceptions applies. As you can see from the slide, a lot of them are fairly specific and may not apply to your industry. But the one that does often come up and where we have already received a lot of questions is the safety sensitive position. So that is defined as a job, including any supervisory or management position in which an impairment would threaten the health or safety of any person. That's all we have right now, right? There's no other guidance about that. There's no, at the moment, we checked yesterday, there haven't been frequently asked questions or other guidance that has come out from the state of Minnesota quite yet, although we're carefully looking at that and following that because we expect that there will be some more information to provide employers some guidance on what that means.
Laura, I'm just going to jump in and ask you a question on this point because
Sure.
this is, we are actually getting a lot of questions on the definition and use of safety sensitive position under this new legislation. What would you recommend as a best practice for employers determining whether an employee is in a safety sensitive position that would require testing?
So I think first that I would not just accept at face value that everyone is safety sensitive, even if an employer is trying to advocate for that. So I had a client call me and say, you know what, we really feel that all of our positions are safety sensitive. Even if it was someone in the office, and I give them actually a lot of credit for it because they were not just, it was not conclusory only. They did say, well, here's why. Like we have, even the HR person will go and give tours in the plant. And so that could be safety sensitive that way. And so we talked through the issue and really tried to determine, is there credible evidence if you got challenged on this? If you had to prove that the person was safety sensitive, what would you be able to work with, right? And so we looked at, well, what are the job duties? If there was a job description, does the job description also reflect those safety sensitive duties? Many employers have job descriptions that have sat around in file cabinets or haven't really been reviewed for a long time. It likely makes sense to take a look at those anyway and see, there's many different reasons, wage and hour reasons, other reasons, so that the job description adequately reflects what the person does and does now. Maybe that's what the person did at one point, but the job has changed and it needs to be revised. But if you were interested in testing someone because you determined that they were safety sensitive, we would highly recommend that any contemporaneous documents that you have about that position, whether it's the job description, maybe it's in the job offer, that all of those things would reflect those safety sensitive duties and that you aren't just declaring that everything is safety sensitive. Again, I think, Mark will talk a little bit more about what is this actually gaining you anyway to test for cannabis because of some of the impairment tests. But there are true positions that are safety sensitive where you would want to have that information. Maybe you can't take action against it, but perhaps it can invite a conversation with the employee in a different way about the importance of not being impaired at work, and that there's a very strict policy about not being impaired at work, and that conversation as a result of that test is happening in a way that you think adds value.
Yeah.
All right. So bottom line, we don't recommend that people call everything safety sensitive. We do suggest that if you are going to test someone, and that's the exception, that you are relying on, that you are carefully looking at that, and that you feel that you have credible evidence to support it. All right, turning things over to Mark now. We've talked already about pre-employment. So now the person is with you. So this is the during employment, and what things do you need to be thinking about, or what adjustments do you need to make as a result of this new law?
Thanks, Laura. That was great info on kind of the parameters of the law and how it relates to employers in the kind of the pre-employment setting. And as Laura stated, now we're going to kind of switch gears and talk about during the employment relationship. And the good news is you can still take action. I'm sure that this is weighing heavy for a lot of employers. It doesn't mean that you don't have options available. You can still take action, but it is a little bit more difficult, especially in certain situations. And we're going to kind of go through that. So that the general rule, and this goes back to what Laura was talking about earlier about the lawful consumable product law in Minnesota. The general rule is you can't discipline or terminate an employee that engages in the lawful use of cannabis so long as that use is off your property and occurs during non-working hours. The challenge with all of this, and this is the issue that I think we're going to be dealing with for quite some time, and we really won't have good answers for some of this until we have some cases presented. But the challenge is cannabis, unlike alcohol, for example, cannabis can stay in a person's body or system for quite some time. So even if you did a test, kind of that snapshot in time when the test is taken and there's a positive test, it doesn't really tell you a whole lot, because that could be from somebody's lawful use the night before, week before, could even be a month before. The science is not super clear on how long it stays in somebody's system. And again, that's part of the challenge with this. And that's why it becomes extra difficult now with this new legislation. So as I said, you still have options. You can still, as an employer in Minnesota, establish a written policy that addresses the use, possession, impairment, sale, or transfer of cannabis. And there are certain situations that are easier to address than others. And I think the threshold question that we should really ask is, one, is the employee using, possessing, selling, or transferring cannabis at work? Or is the employee impaired while working, while on company property, or while operating company equipment? And then generally speaking, I like to lump so that's kind of the threshold question. And then there's 4 different situations, and I'm going to come back to these. I'm just going to rattle them off real quick. There would be reasonable suspicion without a test, reasonable suspicion with a test, behavior that violates an employer's written policy, and then having to take action, again, hearkening back to what Laura was saying earlier, because you as an employer are required to take action, meaning you're required to test because that employee falls under some other set of guidelines. The most obvious one would be under federal law, under the Department of Transportation guidelines. So, all right, so as I said before, the use or impairment piece is difficult because it's quite subjective, and what this comes down to, and the crux of all of this with the new law, is this concept of reasonable suspicion testing. It's not necessarily a new concept, but it's definitely new in how it's used under this new legislation. So again, going back to those threshold questions of whether somebody is possessing, using, selling, or transferring at work, or whether they're impaired, let's look at what I would call bucket one, which is the employee lacks the clearness of intellect and control of self that the employee would otherwise have as a result of consuming cannabis. Well, that's a mouthful. What does that mean?
And what does that mean, and how are you supposed to interpret that,
Yeah,
right?
so I think,
A big question.
yes, so in other words, the employee's under the influence at work or while in the performance of their job duties, and they're unfit to work. And this is where the reasonable suspicion piece comes into play, and it's kind of this baseline test that employers are encouraged to use. And this is kind of a difficult concept because really what the law is saying, this new legislation is saying, is that, hey, look, you have to know your employees. You have to understand what their non-impaired behavior looks like so that you can make a determination under reasonable suspicion if they are impaired. Well, you know, for a smaller employer, that may be easier if you have an opportunity to observe your employees more closely. Maybe easier if you don't have high turnover within your workplace.
Have a key manager that's in charge of
Yes.
that, right? So that there's a bit of consistency in how that's being evaluated. But
Yeah.
you know, that's harder if you have a lot of remote locations, or you know, who's getting trained on this. And I know that's what you're going to talk about a little bit, is you know, training for this too.
Well, think of in the context of a fast food restaurant where there's perhaps high turnover. How are you ever going to establish that baseline? So this is where the reasonable suspicion piece, it's crucial for this new law, but it's very difficult for employers. So again, this first bucket that we're talking about is reasonable suspicion without testing. And before I jump into that in a little more detail, I just want to say, and Laura had mentioned this earlier, the law is relatively unchanged as it relates to random testing and treatment program testing. So employers in Minnesota, so long as you have a written policy in place that complies with that law, you can still engage in random testing for those positions that are in those employees that are in safety-sensitive positions. Laura's already given you some information on, you know, the importance of revisiting your job descriptions and policies as it relates to categorizing employees as being in safety-sensitive positions, and this is in part why. And then treatment program testing. Again, for those of you familiar with that law, if there's a positive test and it's a first-time offense for an employee, you still have to send, whether that's alcohol, unlawful drugs, or even cannabis, you still have to offer them the opportunity to go through, again, for first time, to go through a treatment program. While they're in that treatment program, you can continue to test them, and that has not changed.
At their expense, but it is, like I mentioned, there's a very rigorous drug testing statute in Minnesota, and that's a provision that's different than in a lot of states, that you have to offer rehab for that first offense. So since safety sensitive is on this slide, do you want to address that question that is up here? We got one question about a federal firearm license holder, firearm manufacturer. Most of the employees are required to handle firearms, and would we consider that to be safety sensitive?
I'm going to say yes. That's
that would be
a good one.
my sense too, right? Is that I don't think, like my example of my client that was maybe advocating on safety sensitive, this one does seem, in my view, to be something that would clearly fall into that category.
That one to me seems pretty obvious, just because of the risk of harm to those in the workplace,
right. Like
or the general public.
in which an impairment would threaten the health or safety of any person.
Yeah.
So now maybe not all of the employees are would fall into that, so I would just carefully look at that. But if most of them actually handle firearms, it would seem to me that you would have a very strong argument that that person would be safety sensitive.
Yeah, I feel pretty confident on that one, that would be deemed safety sensitive. Good question. All right, so again, reasonable suspicion testing is really the crux of all this as it relates to current employees. And like I said, there's kind of these four buckets, and the first one is reasonable suspicion without testing. So the question is, do you have some evidence? Do you have some evidence or reasonable suspicion that somebody's consuming cannabis at work, or they've come to work impaired due to cannabis consumption. And again, going back to what I was saying before about this baseline test, that's so important to at least have some understanding of what is typical, I don't want to say normal, but typical behavior of your employees, and then what you might perceive as non-typical behavior. I like using hypotheticals, and I'm going to use one that Laura and I get all the time. It's kind of this loaded question, and for all those who are on the participating and are in HR, you'll appreciate this. An employee comes to you and says, hey, I was just walking into work through the company parking lot, and I saw Jim sitting in his car smoking what looked to be a joint, and he had his window cracked, and it sure smelled like cannabis. So that's presented to you as an HR person, and what do you do with that? Okay, well, if the person who reported it is credible, you've already got some reasonable suspicion now. But oftentimes, employers are quick to want to test. And I think there's a step before that, and this is the reasonable suspicion without testing piece. So I think the first step is if you've got a credible complaint or issue that has been brought to your attention, okay, now, and again, assuming you've got kind of this baseline of what's typical behavior versus non-typical, Jim comes into the workplace after getting out of his car, and let's just say hypothetically it was over the lunch hour, so you've already observed Jim's behavior in the morning, and now you're observing that Jim is acting different. Take your pick. Bloodshot eyes, slurred speech, stumbling, whatever the case may be. Okay, now you've really got some strong reasonable suspicion as it relates to Jim. So what do? Do you test him? Maybe, maybe not. I think the first question is talk to him and ask him and just say, Jim, what's going on? We had somebody, assuming the employee who reported it is willing to step forward or is okay with being disclosed. Hey, we've had a coworker say they saw you and now we've observed this behavior. Were you smoking cannabis in our parking lot? If Jim admits to it, you as an employer can make a decision right then and there. You don't have to test. Because, why? Because the new law says you can't possess on company property. You can't use on company property. We're not even making a determination if they're impaired yet. We're just going through kind of the steps, the process. So there's an opportunity there if you as an employer wanted to. And I can feel Laura about to say, what about that tough labor market? But I don't want to terminate. You don't have to. But I'm saying if you wanted to discipline or terminate based on that alone, you could, because they admitted to it.
Right. And wouldn't we recommend that though, right? Because of the problems with the current ability to find out whether the person's impaired at work. Now, of course, if they're smoking in the parking lot, let's say it's like on a break or before work, the idea that they wouldn't be impaired like right there, is a little more challenging. But let's just take even just an easier example. So say somebody crashes a forklift at work, and you think they smell of cannabis. What would we recommend doing there? Is it immediately test, or is there maybe a different route that's more reasonable and maybe doesn't have quite as few challenges because of the impairment test that currently exists?
Well, great question. And again, Laura and I get these questions all the time, but in that case, you could take action based on the accident alone.
Right.
Especially if there was some, at a loss of words, bad behavior or unsafe behavior that caused the accident.
Damage to property.
Or they were acting, they were goofing around on the forklift and it caused an accident. You can take action based on that. You don't have to test somebody. You don't even have to ask them if they're under the influence. If you wanted to, let's say there wasn't unsafe behavior and it was an accident. Accidents happen. The next step, and this is kind of like I was saying, the first bucket, instead of just immediately going to testing, I always encourage employers in Minnesota to talk to the person first. And if there's an admission there, then you don't have to go through testing. And I may have said this already, but if I didn't, the significance of going this route of asking the questions first and maybe taking action is that if you ask the question and they deny it and then you go through testing, if it's a first-time offense, you as an employer have obligations under DAT law. You can't just take action for a first-time offense. And that's true whether it's alcohol, an unlawful drug, or in this case, cannabis. So that's the benefit of asking the questions first. Okay, so now let's switch gears, same hypothetical, reasonable suspicion with testing. Again, same hypothetical, but when you talk to Jim, Jim says, I don't know what you're talking about. That was a cigarette, and I'm fine. Okay, well, you don't believe Jim because you've observed Jim's behavior coming back after the lunch hour, and it's significantly different than when he left in the morning. So now you're gonna test. As long as you have a written policy in place that complies with that law, as long as your reasonable suspicion, your checklist is not arbitrary and capricious, meaning you've got good evidence, credible evidence, and you're treating Jim like any other employee in this situation, you certainly can test. And if the test is positive, just remember that under Minnesota's statute, you have to get a confirmatory test, but if it confirms the presence of cannabis, we don't know if he's impaired or not, but we've got cannabis in his system. We've got that coupled with this credible observation of the employee who saw Jim in the parking lot. Plus, most important now under this new law, you've got a comparison from the baseline of Jim's behavior to this new behavior. You take action. So that's allowed. Okay, so third bucket. The behavior in and of itself violates the company's written policy. So this is a key takeaway, as Laura said. If you're kind of listening, here's a key takeaway. And I'm gonna talk about this again in just a couple of minutes. But whether you test or not, whether you have a policy that complies with DAT law or not, you should at a minimum in Minnesota, if you want to address these issues, at a minimum you should have what we would refer to as a policy statement that's called now drug-free, alcohol-free, and cannabis-free workplace. Again, it seems odd that you have to specify all three now because remember, cannabis is lawful. So
right,
you could
the
just
definition change. So you don't want to just rely on the drug part in your old policy.
right. So now you could just have that written statement that says it's a drug-free, alcohol-free, cannabis-free workplace. And you could take action again, because here in this hypothetical, again, using the same hypothetical with Jim, let's say that you've confiscated the contraband. You've got a joint, you got an edible, whatever, and it's now you got them dead to rights and it's a violation of possession in the workplace. You can take action because it violated your written policy. You don't have to do anything more. That's it. All right.
We absolutely recommend that employers have a policy saying that you cannot be impaired at work and that it's defined right. And so that is, like Mark said, a big takeaway here is if you want the most latitude to ensure you can take action against employees who are impaired at work, that you need to have that policy.
And that's what Laura and I have been doing a lot of for the last 2 months, it seems like, is looking at policies and revising them. And a lot of it's just tweaking those policies, but the devil's in the details. And it's that those fine points that will determine whether or not you're in compliance with that law and whether or not you can do what you're doing.
Right. And it's very simple to do, but you need to do it, right?
Yeah.
So that's what we want to make sure people understand.
Exactly. Okay, so the fourth bucket, and again, I don't want to belabor this one too much because Laura's talked about it, I've mentioned it as well, but the fourth bucket is you have, you're required to take some action because your employees are either safety sensitive under this new definition, or they fall within, for example, a Department of Transportation right where you've got to take action. All right, so terminating employment, again, this is just a quick summary, and this is why I said the 4 buckets. This is it right here. These are the 4 buckets. 1, employee lacks clearness of intellect and control of self. 2, testing is authorized and you do test and it's positive, and that's supported with reasonable suspicion, of course. 3, it's a violation of your policy, your written policy, or 4, you're required to take action. All right, so takeaway, again, to Laura's point earlier, if you're kind of listening, here, listen a lot right now.
As engaging as we are.
Listen closely now. Okay, so update your policies. Again, this is the stuff that we've been talking about for the last 45 minutes. Review your policies and make sure that regardless of whether you have a robust DATWA policy that allows you to test, there are changes you're gonna have to make to that policy for sure. But as we said, also take a look at your general policy statements, your drug-free, alcohol-free, cannabis-free workplace policies. Reasonable suspicion training. This is key. Again, under this new legislation, this is key. We're going to find out more as we get cases on this for sure. But what we can tell you right now is have 1, ideally 2 people that are trained on reasonable suspicion testing and they understand what that means. And going back to kind of that baseline that I was talking about earlier, we know it's difficult, especially if you're a larger employer or you have high turnover. But the easy thing you can do is in your performance reviews, whether that's annual or even more frequent, you can kind of start developing that baseline as to, talking about somebody's performance and behavior within those performance reviews. And that's also, allows you to develop that baseline.
Yeah, on the reasonable suspicion, like we have a checklist and can help people train. And so if that's something that anyone's interested in getting more information, we're happy to do that. But as Mark mentioned, the important part is doing the training. So if you have resources you should certainly use them, but we could be one as well if you wanted.
Yeah, absolutely. So going back to something Laura said earlier, making sure you're going through those job descriptions, and more importantly, not just because this happens all the time with us too, job description may say X, reality is they're doing Y. So making sure that those 2 things sync up, but if they truly are safety sensitive under the new guidelines, classifying them as safety sensitive. So you've got more latitude when you're taking action.
Take that question.
So
there was another question about whether auto repair technicians would be considered safety sensitive.
Good question. So I'm going to go back to the point that you read earlier about the threatening the health or safety of any person. So an auto repair technician, let's say somebody who's working on brakes or tires or whatever, it involves the safety of an automobile. I would say that could certainly fall within the realm of a safety sensitive position. Do you agree with that?
I think so, yeah. You'd want to make sure you're looking at if every position, but it seems generally speaking, and again, like this is brand new, like all we have is that sentence. We're looking for more information and frequently asked questions, but I think that you would have an argument that position would be safety sensitive.
There's a question that just came in about vaping, and I'm going to get to that question in a minute because as soon as I'm finished with this, I'm going to switch gears to just businesses in general. So I just want to get through these best practices first. Again, making sure somebody's up to speed on reasonable suspicion testing, building in regular routines regarding documentation, important. And now wanting to switch gears to this last part, which is not so much employer-employee related, but rather what rights do you have, what obligations do you have as a business owner? And bottom line is businesses that are not licensed to permit on-site consumption of cannabis could face legal liability. I emphasize could, we don't know for sure yet. There are statutes out there, both on the state and local level, that address individual liability for people that violate this policy, but it's not entirely clear yet whether the business would face liability. But let's just talk about kind of the general rule. The general rule is cannabis is only permitted the only permitted places of consumption are private residences, private property, unless the owner objects, and an establishment licensed to permit on-site consumption. So I'll give you, and by the way, this does not apply to medical use of cannabis. We're just talking about non-medical lawful use. I'll give you a hypothetical again of somebody, a customer who is using cannabis or possessing cannabis on your premises, and let's just say because of that, because they're acting in an unsafe way, whether it's one of your employees or just a member of the general public, somebody gets injured on your property. Well, look, you've got premises liability no matter what. And hopefully all of you have insurance coverages to address that. But if you allowed somebody, knowingly allowed somebody to use or possess on your property, which was open to the public, and you weren't licensed to do so, I think it's going to take it to not a strict liability situation, but a bigger exposure to you as a business owner, negligence for sure, if somebody gets injured because of that behavior. So again, this is not clear yet by any means as to what the liability would be to a property owner, but I think common sense would dictate that, look, you've already got premises liability because you own the property. And if you're allowing for some unsafe behavior and potentially unlawful behavior as it relates to that individual to take place on your property, I think your exposure is greater. Furthermore, there are local ordinances that address this. Brainerd, for example, has an ordinance now that talks about you can't smoke or vape cannabis in a public place of accommodation, or in a place where the smoke could be inhaled by a minor. And this, going back to this question, I think there's a question earlier about is vaping cannabis legal and an issue? If you're not
customers on a charter bus.
Yeah, there's two different scenarios there. There's the employee and then there's the customer. Again, if it's the employee vaping on your premises, then that's company property, that's addressed.
More customers, right?
Yeah, and if we're talking about a customer here, if you're not permitted, if you're not licensed, which I'm going to assume in this situation you're not, then there's exposure. There's certainly exposure for the individual. There could be a criminal violation for them, but I think as time will tell, there's potential criminal exposure for a business owner, certainly civil liability, because if somebody gets hurt because of that, I think you're on the hook either way.
So they could say no.
Oh yeah, absolutely. You can say no.
I think
Yes.
that's what I'm
Sorry,
reading between the lines,
right.
Is that like, so if that's not what you want, right? Like what should you do about that, right?
Yeah, you can stop that. You can say that's not allowed, and whatever the situation is, tell them to stop, remove them from the premises, whatever you need to do. And obviously, if you need to, contact the authorities.
All right, so there's a couple of questions about safety sensitive, and one thing I was gonna mention is that if we kind of just get back, why does it matter if something is safety sensitive or not, right? So it's not really, to start with, whether someone is safety sensitive or not, that does not mean they can be impaired at work. So you're all gonna have great policies that say people can't be employed at work. And so irrespective of whether it's a stretch or it's not clear if something is safety sensitive or not, that doesn't mean that they can be impaired at work. So one of the questions was about bartenders or servers who are responsible for checking IDs. Those people cannot be impaired at work. And so, so you want them to be sober and making good decisions about that topic. Now, is that position safety sensitive? I think that's a little unclear, right? I think you could argue, well, if they're impaired, that could threaten the health or safety of any person, but it's not quite the same as somebody that is handling heavy machinery or whatever, right? I mean, I think this is one where I think there would be an argument. But this all again is like, what does that get you if the person is safety sensitive? What that gets you is the right to pre-employment test for cannabis. So if you're not actually interested in doing that, then maybe this is less of an issue, right? Or there's the random testing that can be done.
Correct.
But to kind of back into it, it's because, you know, it's an often question, but like, let's not forget the fact that what does that even get you, right?
I think it's a great
you.
point, because random testing is just not, we don't see a lot of random testing anymore.
Right,
quite
and you
honestly.
may not pre-employment test for cannabis anyway, right? And so like maybe it's less of an issue. A woodworking company,
Same.
I think a lot of those positions likely could be safety sensitive, but
Depends
again,
with the equipment and you know, could they harm themselves or a coworker or a member of the general public?
right, and I think it's a case by case analysis
Yeah.
on each position, not just on the industry or the whole company altogether, right? There may be certain office positions where that's not safety sensitive. But again, that doesn't mean they can be impaired at work or that it's not an important issue. It's just that you may have fewer, you may have less of an ability to pre-employment test for cannabis and random test,
Great point.
right?
And said another way, just because you determine that they're safety sensitive, it gets you a little more leeway, but it doesn't mean you have carte blanche to do whatever you want. And I think your point's valid. If you're not doing pre-employment testing, you're not doing random testing, I'm not sure it's gonna make a lot of difference. Focus on the impairment.
Right. And so, and I think there are, like I said, fewer and fewer clients that are actually doing pre-employment testing right now because of the tight labor market. And so, again, reinforcing your policy on not being impaired at work is important. But maybe, you know, and again, if there's more questions about this, we're happy to talk to people.
But it goes back to what I was saying earlier. You don't have to have a policy that allows for testing. You could just have a statement.
Right.
You know, drug-free, alcohol-free, cannabis-free workplace statement. And if you're, if somebody admits to being impaired or, you know, they violated some clear rule that they've possessed or used, you can take action based on that.
Right, so there's a question here about on-site housing. So like the employees are on company property if they're on on-site housing.
And they can't use or possess, and if they're impaired while they're on your property, then you go through that whole analysis, the reasonable suspicion. And again, if they admit, you can take action, and if they don't, you've got a policy that allows for testing, you could test and take action.
So then I think the final question here is, at what point can you turn away someone that's impaired? This person has a zoo and it says a high risk to public and animals. So looking at kind of what's permitted and
Yeah, again,
how do you manage that?
I think it goes back to this point about would it threaten the health or safety of any person? And I think you have to ask yourself, and you know, within reason, is this person really a risk to the health or welfare of the public? Animals are not included. There's nothing in the definition yet that, you know, talks about harm to animals, but if it's harm to the public in a way that, you know, they open a gate or allow an animal out, then yes,
Right, and then if they're using, well, you know, if it's a customer, right?
That's
then,
good, yes.
right,
Yes.
but like how to manage that. So Matt, are we at the end of our time here? Hopefully it's okay, we address the questions ourselves, so.
Yeah, this is perfect. I'll give you one more general question that's probably on everyone's mind. This kind of harkens back to the COVID crisis when the governor's issuing executive orders and then we have to wait for guidance, and nobody wants to relive that, but that's what it reminds me of. Do you have any insight as to when they will launch the Office of Cannabis Management to address some of these issues, like the safety sensitive positions? That's going to come up over and over and over again. I know the Department of Health is fielding questions on that right now, but do you have any insight there?
I don't have a sense
I
of
don't
that,
either.
although a lot of that, as I understand it, is building out the infrastructure as it relates to the dispensaries. And I think some of that is going to take quite some time. But it doesn't mean that there couldn't be some frequently asked questions that would come out on these topics perhaps sooner than that. So we're hoping that we get some more guidance on that because I think that's the area that we are getting most questions about, and where it's, again, that one sentence, so we're all interpreting that and trying to make reasonable decisions about what that might mean, but I think there's a lot more guidance that could be provided that would be helpful to employers.
We're hearing 12 to 18 months for, firmer guidelines and rules for dispensaries, and obviously we're not gonna be able to wait that long on some of these issues that we've addressed, so I think this stuff is gonna come up sooner.
Yeah.
We hope.
Well, thank you. Excellent presentation. I think you addressed a lot of questions. Really appreciate all of your time and everyone for joining today. Just as a quick reminder, we will send out, I believe you have your permission to send out the PowerPoint presentation. We'll send out a link to the recording. You have that really wonderful FAQ article that we'll send a link to as well. Thanks everyone on behalf of the Brainerd Lakes, Cross Lake, Cuyuna Lakes, Nisswa and Pequot Lakes Chambers. Really appreciate your time, and we'll send out more information soon.
Thanks,
Have a great
Matt,
day,
for the
everybody.
opportunity.
Thank you so much.
Thank everyone.
Thanks for having
Thanks, everyone.
us.